Good afternoon, everyone. This afternoon, we're going to be talking about inflicted injuries in care proceedings, and in particular, what the law says about what needs to be proven, how you challenge evidence in those types of cases, and what good practice might look like for such cases. Our learning objectives for the afternoon will be to consider the relevant law, and by that I don't just mean the law that is relevant to cases of inflicted injuries, although we will cover that, but more generally the law around what needs to be proven and how you do that in care proceedings, because of course that's very relevant and sometimes a reminder of the basics can assist us in moving forward. As part of that, we're also going to look at what best practice can look like, and we're going to try and weave the two together as we go along. We're also going to look at what you as practitioners can do to support your clients. And by that, I mean the local authority themselves, the social workers, I mean the parents or the interveners who are accused, and possibly even the guardian who might end up sadly being involved in these types of matters, or the children who might be making allegations. Now, when I say inflicted injuries, what I mean really and what I'm talking about are the kind of cases where there have been allegations of either physical abuse, where there have been cases of fractured bones, shaking, baby shakes, that sort of thing, where there are these really serious injuries around who has inflicted those injuries, if they are inflicted at all, or if they're accidents, and what the law says about how we deal with them. Those cases can come in two forms. They can be single issue cases, and we see many of those being single issue cases with parents who otherwise would not have safeguarding concerns around them, or they can be the kind of cases where there are wider safeguarding issues, substance misuse, mental health issues, etc. And part and parcel of those cases can include some elements of inflicted injuries. And we will discuss as we go along what might be proportionate to litigate and what might not be proportionate to litigate in those kinds of cases. So let's start with a very basic overview of the law. We know that in care proceedings, the allegations have to be proven to the standard of the balance of probabilities. I'm not going to labour this. You all know about the case of the Matter of X 2015. By way of reminder, though, for those of you who either don't know it or have forgotten the facts of that particular case, well, this was a case concerning 4 children between the ages of 3 and 13. Their parents had separated, and in March 2015, their mother, their maternal uncle, and their grandmother were detained at the airport as they were about to board a flight to Turkey with the children. When the items that they were carrying, their luggage, was searched, they found things like ISIS flags and to-do lists written, which the local authority took to mean that they had an intention of moving to join up to be ISIS militants and supplied those people with items to use, and that as a result of that, they were exposing the children to risks of harm. Of course, they were going to Turkey at the time, though. Sadly, the mother's case didn't help her in particular, because of course, not only did she initially say she was going to Turkey for a holiday, she later said that she wouldn't resist findings being made, that in fact she was flying out to join ISIS militants. And then she later said that she was going out there simply to marry a gentleman, not to join ISIS militants. So her explanations were inconsistent. There were real issues around her credibility. But what it fell down to was whether, in fact, the local authority could prove that this mother had intended to move on to Syria with the children, that this mother did intend to join ISIS militants, and that as a result of that, she was taking the children to a war zone. The president at the time, Mumby, considered this case, and he described it as the kind of case where you really have to go back to basics and you have to look at what the local authority is able to prove. Because whilst the mother might not have been the most credible of people, remember that ultimately that doesn't reverse the burden of proof. The burden lies on the local authority at all times, balance of probabilities. The findings that a local authority seeks and the court will ultimately make, if the court agrees, must be based on evidence, not just assumptions, speculation, suspicion that we might have around what the mother intended to do by going there. The local authority needs to be able to evidence that that's what the intention was. When it comes to experts, experts can express opinions which should be in their own fields, so they mustn't cross over. But experts' opinions, however powerful they may be, are only part of the picture. And it is up to the court to look at the evidence in the totality of the evidence to decide what has happened in a particular case. The court also reminded us, of course, around lies and the fact that people lie for many reasons. And it isn't always the case that when someone tells a lie, it's a sign of guilt. So the matter of X was a very, very basic case that set out the law in a very basic form, but certainly worth noting because it would impact on cases of inflicted injuries. You might say to me, well, how necessarily, what should we take from that when we look at these types of cases? Well, I would say if you act for a local authority, it's a very stark reminder of don't assume that you will get over the line. Don't assume that you've got a threshold in the bag. You have to gather your evidence, especially in cases, I think, where the inflicted injuries or the allegations of inflicted injuries are single issues in the cases, because in those circumstances, you might end up having quite a strong argument against you to say, well, these are not the kind of people who would ordinarily hurt a child. They have no propensity to do so. In these cases, when they come to court, and you have to consider whether this child or these children might have been the victims of certain forms of abuse through inflicted injuries or not, I urge local authority representatives to don't take for granted the evidence. The expert evidence is useful and you must get your experts there, but it's not the whole picture. Make sure that if you have a family who isn't well known to the local authority, you get an assessment done of them before going to a finding of fact hearing or a composite final hearing. Often local authorities will not do an assessment of the family. Even if it's an interim parenting assessment, a child and family assessment, get some information about this family, understand what's been happening on the ground. It might flag more safeguarding issues than you realise. Make sure that if there were professionals who were involved from school, health visitors, family support workers, we get statements from these people to understand what the family was functioning like. Think about issues like if substances are part and parcel of the family's history, get substance testing done. If mental health issues are part and parcel of the situation on the ground and the impact on the pressures on the parents, think about the need for psychological and psychiatric assessments. Think about, and of course, obtain police disclosure, but also think more widely about what other form of professional disclosure you might need. So, for instance, if there are family members in prison who might be involved in domestic conflict, and that might be a relevant part of the finding of fact process, get prison records. If you are concerned about the discussions that the family members have had and whether they've been fully credible and whether they've been hiding things and discussing them on their phones, for instance, apply for mobile phone analysis disclosure. All of this is really important evidence that you want to think about and apply for early. If you're either for the local authority or if you're for the child trying to get to the bottom of these things, remember, as part and parcel of this, you have 26 weeks, and the president has become a lot more rigid on us trying our best to conclude in 26 weeks, reminding us of the statutory duties. You can't leave these things for very long. So I always advise local authorities or the child, if I represent the child, to gather this evidence as soon as possible. You might not get the chance later on to make such applications to get this kind of evidence if it's likely to cause delay. If you are for the parents or the accused or the intervener, sometimes often many in the same or overlapping, you want to think about what you want to say on behalf of those parents. I don't sit here and tell you there's a clear strategy to this, but the general rule, I think, would be if it is a single issue case where you otherwise have parents who don't have wider